designates in favor of a particular group, can others use the exact same objection that you're offering?
I'm not sure I understand the question.
Well, would they be able to challenge the same way that you're challenging a positive designation?
Got it. So no, Your Honor, but not because of the review bar. What they can, the statute says the secretary may designate, this is now we're talking about B1, right?
Yeah.
May designate only if, and then one of these three criteria have to be met.
Yeah.
So even if a country is horribly in crisis, there's no obligation to designate. And that's the reason why that's unreviewable. But of course it doesn't cut the other way, right? On their view, if the secretary, this is my opening hypothetical, if the secretary designated Mexico for immigration relief, it's unreviewable. On our view, it is reviewable because you will look to the criteria to see whether they actually applied. Did they care at all about conditions, or were they just trying to achieve some political end?
Yeah. Justice Alito?
One of the points that General Sauer made was that if we accept your arguments, it will create a hole in the judicial review bar that you could drive a convoy of trucks through. And you have now said repeatedly that it's necessary for the secretary to turn square corners, which seems to support what he says, that if we depart from the ordinary meaning of the review bar, then it is always going to be possible to pick procedural faults to raise procedural objections to what's been done. And what you've said about consultation makes me think that may be true, because here there was some consultation. All right, it was very brief, and maybe it's not what one would hope for, but still, once you say, well, it's permissible to review the adequacy of the consultation, it's always going to be possible to pick to raise objections about the adequacy of the consultation and the words that the State Department comes back with.
So two thoughts, Your Honor. First, our consultation claim in this sense is extremely narrow. We don't argue about the levels. We don't argue about the amount. All we say is it has to be about a subject, deliberation about a subject. So they have to talk about country conditions. And you could hold that, Your Honor, and leave aside, just say, we're not saying it's okay to police meaningfulness, even though in other statutes, lower courts do, consultation claims, consultation provisions are in other statutes, and the sky doesn't fall. But if that's Your Honor's concern, just only say it has to be about the topic, and we don't say anything about meaningfulness in a broader sense. That's my first answer. My second answer is, the State Department actually provided reports, because they did care about speaking in one voice for 35 years under this statute. This is in the former senior government officials brief, as a bipartisan brief, including somebody from the first Trump administration, talking about the fact that they used to actually look at all the different components of the State Department and talk about this so that they could make sure that the decision was good. There was never a challenge to consultation under that. Even in the first Trump administration.
Do you think that sort of elaborate process is necessary?
No, that was the first time there were other TPS challenges. Before that, 16 terminations, never a challenge, right? It started then. Even after that, this consultation claim has only arisen because now they're doing the form email.
Thank you. Justice Sotomayor?
Justice Barrett sort of was asking a question about almost sounded a little bit like harmless error, even if they didn't consult. That's okay because, they were going to make the same decision. How do you deal with that? I mean, this is a due process claim, and we've never said what the final determination is important to due process, correct?
Yeah, correct, Your Honor. I think I would say two things about it. First, there isn't a basis in this record to say that she would have done the same thing if the state, particularly on the armed conflict designation, where national interest is not a criteria. So you have to find—
That's under the A section of the statute.
Correct. It's under B1A. There's two designations for Syria, one under armed conflict and the other under extraordinary temporary conditions. Our position is that even under the latter one, it is not permissible to consider national interest at the periodic review stage, because what is required is that there be review of conditions in the foreign state. And we think when the word conditions is used, just a couple lines later, it's referring back to conditions in the foreign state and not criteria, which is what my friend kept saying. And if you look at the word, the name, the label of it is extraordinary and temporary conditions, which is talking about country conditions. B1B also says living conditions. So every time the word conditions is used in subsection B, it's talking about country conditions. National interest is not a condition, right? So that's our argument, our argument on the merits as to the second one. But on the first one, even as to process, there's nothing in this record to tell you that if they had actually consulted, the secretary would have said, I don't care what the State Department says. Maybe she would have said, oh, wow, that's not good. And they would have perhaps, led to a different view. And so I think even if harmless error is permissible in this context, there just isn't a basis to find it. And it is, again, important for the government to speak in one voice. And I think that would be the benefit of enforcing the consultation requirement here.
Well, I mean, the whole purpose of the TPS is to ensure that the executive is open about what it's doing, correct?
Yes, Your Honor. Transparency is all through the statute, Your Honor.
And so to the extent that a president says, it's not safe for these people to come back, or I'm unwilling to say it's safe for those people to come back. Haiti shows that 4 of the people who were sent back, that have gone back, were killed. So I'm not going to say it, but I don't care. I'm still going to end the program. That's a different impact than saying it's safe. And I have an alternative reason anyway.
It absolutely is, Your Honor. And I think it's also important to remember that this issue about whether you can terminate on the basis of national interest, it only arises if the country is still unsafe, at the alternative ground, right? It only arises if the country is still unsafe, and as to people who have been able to keep their TPS, because despite being vetted 18 months, every 18 months, resubmitting their background, resubmitting criminal history checks, they have been found not to have even a single felony or more than 1 misdemeanor or any of the other grounds. So we're talking about the power to mass expel people who have done nothing wrong to countries that remain unsafe. And our view is it is unlikely that a refugee protection statute would have given that power to the secretary.
What do you do with, there are 2 pools here. One is the people who have been given TPS status for a long period of time, and the new applicants for which there hasn't been checking yet.
Yes.
Could a president come and say, I'm not going to terminate the program because the country's still not safe, but I'm not going to give new applicants permission to stay because I can't vet those guys?
Yes, absolutely, Your Honor. So in the periodic review process, there's 3 options. You can terminate, you can extend, and if you extend, you can also designate again, but you don't have to. If you designate again, that updates the date and has the effect of then bringing new people into the eligibility criteria. But the statute doesn't mandate that. It mandates extension if the country is unsafe, but it does not mandate designation. That is like a new designation. And so absolutely, the government could take the position, either individually or categorically, that we're not going to do any new designations, no more TPS holders, but this fixed population, the people who already have it, and have come to rely on the fact that if the government determines that their country is unsafe, then they get to stay, that closed population would still be protected, Your Honor.
So that answers the general's position about this being a pull country in some way, that our policy is a pull?
Yes, Your Honor. I think my friend for the Miat plaintiffs will also point out that there's no evidence for this claim about the pull factor. I'll leave that to them. But yes, Your Honor, there is no need. You can just solve the problem by saying we're not going to let any new people into the program. We are going to limit our extensions to countries that are unsafe for people who already have TPS.
The people who are here, however, and previously been vetted, no, there's no new problem with that vetting for them.
No, Your Honor. In fact, the statute requires that their TPS be rescinded if they commit a felony or become inadmissible on any of a very broad set of grounds. So it's extremely narrow protection. But if they do nothing wrong, then and their country is still unsafe, the statute requires that they remain protected.
Thank you.
Justice Kagan?
Your argument that the national interest claim is reviewable seems harder to me than the procedural argument. And here's why. I mean, I would have thought it's just a version of an argument that is made all the time when it comes to administrative action. Like you took the wrong factors into account, or you didn't take the right factors into account. That's a kind of standard part of arbitrary and capricious review. And I would have thought that if this judicial review provision does anything, it basically says, don't subject the Secretary's determination to arbitrary and capricious review as we know it. So why should we treat this argument, this national interest argument, any differently?
So I think there's some categorical distinction in my head between an argument like, oh, you looked at the earthquake recovery in this portion of the country, but not in that portion of the country, or you didn't consider this evidence about how the armed conflict is, the southern part, but not the eastern part. Those are still within the purview of the statutory criteria about armed conflict or temporary living conditions, right? But it's something else if the Secretary says, oh, I'm terminating the armed conflict designation because there's been earthquake recovery. But earthquake is not a criteria for the armed conflict. It's only a criteria under B1B.
Well, that makes it sound as though if there's any legal error attached to the Secretary's determination, review can come in. And are you reading the review provision that way, that it's just about factual errors, not legal errors?
I do think there can be. I mean, when we're talking about Guerrero-Lasprilla and Wilkinson definition of legal error, obviously that might be broad. I don't think the court has to say that those are reviewable, but the claim that we're making here is that the national interest, you heard me say it, right? The national interest is only at the outset, and it's not in the periodic review, because periodic review is a conditions analysis, whereas national interest is not described as a condition. It's in contradistinction to conditions. That is a pure question of law. You don't need to know anything at all about facts in order to assess that criteria question. And Your Honor,
But it's also very easy for Congress to write a review provision that's confined to non-legal questions, and that's not what Congress did here.
That's true, Your Honor, although they also can easily say all questions
this has nothing to do with, like, even if I read this statute as saying determination is with respect to the determination about country conditions, but if you're in that world where the question is, like, how did you determine country conditions, whether you made a factual error, whether you made a legal error, Congress in this provision seems not to care.
So I agree that this provision doesn't read fact law into it one way or another. I think our narrower argument, Justice Alito had said, oh, I took the question to be maybe I'm not buying your full board determination argument. Do you have anything fallback? And what I was saying was, if you don't want to take the full textual view, then read it against the backdrop of administrative law, where obviously this court generally, or courts generally, have the last view on questions of law. But I think if you say, no, that's not what they're doing here, so some legal questions are going to be barred, what I would say is, whether or not this is within the scope of the determination, that is what we are disputing, right? Because we're saying it's not a country condition, because it doesn't use the word condition to describe it, and the review provision is limited to conditions in the foreign state, and this is not in the foreign state. So at least that claim, the threshold question of, like, do you get into the reviewability bar or not, that should be reviewable, even if once we're in it, you would say, like, a legal dispute about which kinds of conditions should be in it or not, that would be barred. And we don't believe that necessarily is the case either. But just to be clear, like, our claim is at the very highest level. It's just about the criteria of even what counts as a condition.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
How many Syrians have returned to Syria since the end of the Assad regime, and is that of any relevance to what you've been saying about country conditions?
I mean, I'd say the same thing that I said to you earlier, Your Honor, for two answers. First is, it is of no relevance, because even if the Secretary is right and the State Department is wrong, it doesn't change the fact that they didn't talk to each other, and the national interest is not a criteria, and those are claims that are clearly reviewable under the statute. So A, that's my answer. Second, it is true that many people have gone from Lebanon back into Syria. But if we're reading the newspaper now and sort of outside the administrative record, there might be good reasons why people are going from southern Lebanon back to Syria if they're having to pick between the two places. And that is not the same thing as saying, oh, we're going from California to Syria. And so I don't think the fact that you have this mass movement of people is necessarily indicative of whether it is safe to go there or not. As I said, there is still active armed conflict. There's bombing happening now in Syria. So, it may be better or worse. Some people say the mortality rate is higher. I haven't, I don't know. But anyway, I think it does not answer the question ultimately, even if it did, we still should win.
Thank you.
Justice Barrett? Justice Jackson?
So I'm interested in the standards applicable to our decision-making in this case. And one of them is the thought that even if determination could be read to mean different things, the final conclusion or close to it versus the final conclusion plus the antecedent steps, I thought we had a presumption of reviewability that was supposed to apply to our interpretive analysis in a situation like this. So am I wrong about that?
You are absolutely right, Your Honor. It's applied in Bowen, in McNary, in Catholic Social Services, and of course in Guerrero-Las Prias,
So when Justice Thomas says, well, the background is that we wouldn't interpret this if we're sort of trying to figure out what determination is, we wouldn't allow for you to review it. I think the opposite is true. In other words, there's some confusion about the scope of the express determination, the express review bar. I thought our rules under our precedents say you're supposed to interpret it narrowly.
Yes, Your Honor. Two things on this. First, the presumption is clear that they have to show clear and convincing evidence. So the question is, is what we have said by hooking it to determine or read it against the 100 years of administrative law good enough to just get above what would be needed, to beat clear and convincing? And I think it is. And the second thing I'd say on that subject is, Your Honor, Biden v. Texas, from just a couple of years ago, this court holds the APA governs the DHS's parole policy, and it has to be reasonable and reasonably explained against, and it reaches that holding. Every justice of this court endorses that idea in the face of a jurisdiction stripping argument, which the government makes about the scope of the injunction, and all of that I'm sure you all remember. And so it's both true that as a general matter, this court has applied the presumption in both large and small immigration cases, and also that it has done it particularly in a context like this one, where the issue was about whether Mexico, basically the U.S. had to be forced to negotiate with Mexico.
All right, and my second issue about standards, is there a clear error standard that is applicable to the district court's findings here, findings of fact, for example, about whether or not there was likely discriminatory intent with respect to this policy?
Yes, absolutely, Your Honor. It is both true. There's double deference, I would argue, because it's both here on preliminary relief. There may be more evidence to come if the case is allowed to survive. Certainly the constitutional claim is going to be allowed to survive, given on jurisdiction anyway. And in addition, because factual findings are reviewed for clear error in general, then it is true that the clear error operates there. I think that now, since we have the email about consultation and we all agree that that's the scope of it, it's not really relevant. You can read that one page of our brief.
Or it's just so obviously not an error, not a clear error as a result of that evidence, right?
Yeah, well, yes, Your Honor, absolutely. I mean,
we're still applying the clear error. You're not saying jettison the clear error standard. You're just saying, look at this evidence. If the district court found it to be that the email in terms of consultation or the discriminatory intent in terms of what the president said, our burden is to determine whether or not she made a clear error in her fact finding related to those issues, correct?
Yes, absolutely, Your Honor. And the last thing I would just say about that is on the pretext claim, where I know maybe everybody doesn't think that we have all the evidence. It's not the evidence as was in Commerce, because it was a full trial in Commerce. I think in that context, too, it is relevant that we are here on preliminary relief, because the district court was looking at it, and that's what she thought.
Thank you, counsel. Mr. Pipoli?
Mr. Chief Justice, and may it please the court. For decades, administrations of both parties successfully terminated TPS designations without inviting litigation.
Nous suivons un débat qui a fait dans la Cour suprême, ça les cassations dans le pays d'Haïti, et côté que il y a 9 juges,
but was instead
les justiciaux qui ont considéré cause TPS pour Syriens et TPS pour Haïtiens. T'as nous sortant des avocats et pour Syriens yo qui t'a parlé qu'on y a c'est monsieur Jeffrey Pepoli, lui-même c'est avocat pour Haïtiens yo.
Forced to include rationales for termination that had no empirical support. The true reason for the termination for the termination is the president's racial animus towards non-white immigrants and bare dislike of Haitians in particular. The president has disparaged Haitian TPS holders specifically as undesirables from a, quote, shithole country, and days after falsely accusing them of, quote, eating the dogs and eating the cats of Americans, he vowed that he would terminate Haiti's TPS. And that is exactly what happened. Recognizing all this, the district court correctly postponed the termination. This court should affirm, and I welcome the court's questions.
What weight do you, how would you interpret the jurisdiction stripping provision?
No different than the Doe plaintiffs do, Justice Thomas.
More generally, is there anything that your friend said that you disagree with?
No, Justice Rob, Chief Justice, Mr. Chief Justice, my apologies.
Whatever.
Well, can I ask about your equal protection claim?
Certainly.
Is this a race claim, or is it a national origin claim, or does it matter?
It's certainly a race-based claim. We would argue, given the as some of the questioning earlier got to, the evidence certainly suggests racial animus, which the Arlington Heights framework is specifically designed to suss out. The statements, I would like fewer people from places like Haiti, that were described with the word that I won't repeat again, and countries like Norway and Denmark and Sweden. As Justice Sotomayor suggested earlier, that's very close to what we had in Arlington Heights itself. So we do frame this as a race-based claim. We do think it's racially motivated, particularly in light of the cross-cutting terminations we've seen, as the district court in our case put it, 13 up, 13 down, all non-white.
So is that it? It's not Haiti particularly. It's all these countries have people of color, as opposed to Denmark and Scandinavia generally, and whatever.
Sure. I certainly think that the record supports the idea that the president in particular has focused in on Haitians, but it is broader than that. Haitians are our plaintiffs, but the relevant group here is all TPS countries, all of which are non-white.
And what if one thinks that, if you said there was a determination that no matter what, there was going to be a change to Haiti's TPS status. There seems to have been a pretty clear determination that all DPS status should go, right? There's no TPS status that hasn't been renounced. So how does that factor into this equal protection claim?
Well, sure. Our position is that you cannot have, for whatever reason, race-based or otherwise, an agenda to end TPS, because these are country-specific.
Quite right, but that's a different kind of claim. I guess I'm just wondering, how to think about the racial component of this, if there seems to have been, wherever and whatever TPS I can find, it's not going to exist tomorrow.
I'm sorry, I'm not following. The race-based.
There's you can argue that there was just like a across the board, we have to get rid of all these TPS and the statutory requirements weren't followed, and all of that. But the injection of this racial component into it, I guess I don't quite see how that operates when all of these programs went.
Well, again, I would point you back to both the president's statements and the secretary's statements. The secretary herself described people from Haiti and from 18 other all non-white countries as killers, leeches, entitlement junkies, saying we don't want them, not one, while simultaneously enacting a policy, another humanitarian form of relief for white and only white South Africans. So if you want the comparator group, that's part of it. And it's true that the program, the refugee program under which the white South Africans were admitted is not TPS as such, but both statutes are motivated by the same policy motivated by the same policy. They're both humanitarian programs. In both TPS and with the Special Refugee Program, it's the United States saying, these folks are facing some hardship in their home country, at least that's the stated basis, and we're going to let them in. So it's the president's statements in which there is a comparator group, white versus white, non-white countries versus white countries, and it's the fact that you've got those sort of sentiments being articulated into policy.
But more directly to Justice Kagan's point, isn't your view that the reason why the president was saying all of the TPS programs have to go is because the TPS program relates to countries that have large minority or large racial compositions?
Yes, that's exactly right.
In other words, the motivation for getting rid of all of them is that these programs, quote unquote, benefit these kinds of people.
Yes, that's exactly right. And I apologize if I didn't follow that, but yes, that is absolutely correct. And under Arlington Heights, the racial motivation need be only one of many factors. In every government policy I can imagine, there is a facially legitimate reason given for the termination and for the government action. The Arlington Heights framework exists precisely for the purpose of sussing out whether impermissible racial considerations were impermissibly in the mix.
Isn't it the case that TPS was terminated for quite a list of countries? I can't seem to find the particular page of the transcript where the district court goes through them all. And yes, none of those is a Nordic country. And I don't like dividing up the people of the world arbitrarily into three racial groups. But you say they're all non-white, and that's the distinguishing characteristic.
That is the distinguishing characteristic that the district court held. But I would emphasize, Justice Alito, that.
But do you think that if you put Syrians, Turks, Greeks, and other people who live around the Mediterranean in a lineup, do you think you could say those people are that all of them, are they all non-white?
I understand that Syrians, I think, may be classified as white for purposes of the State Department, or for under certain government programs. But again, I think race is, I think, you'd have to poll the public to know what they think the race of a Syrian is. I certainly think they're not white.
Poll the American people?
Well,
do they think Syrians are white?
I wouldn't think that most would, Justice Alito.
Really?
I really don't.
How about Turks?
I honestly haven't considered what racial component I would sort Turks into.
How about Greeks?
I don't know the answer to that either.
How about Southern Italians?
Well, certainly 120 years ago, when we had our last wave of European immigration, Southern Italians were not considered white. So I think our concept of these things evolves over time.
How about Spaniards?
I think same answer. About 120 years ago, I don't think they were considered white.
You have a really large, you have a really broad definition of who's white and who's not white. As I said, I don't like dividing the people of the world into these groups.
I understand. I would say that even under this court's rationality jurisprudence, if you look at cases like Moreno, it is not necessary for us to get strict scrutiny to win here, because irrespective of how you do the classification at issue here, under those courts, under those decisions, under those precedents, bare dislike of an unpopular group is a sufficient basis to find that rational basis is not even satisfied.
Given your understanding of the review bar, wouldn't your APA arguments be exactly the same if there were no review bar? In other words, what function does it, with respect to your APA arguments, in what way does the review bar restrict what you want to argue?
I will give the same answer that counsel for the Doe plaintiffs gave, which is that that determination has the same meaning in the TPS statute that it had in the SAW statute at issue in the McNary case, that in that case, the antecedent obligations procedurally were subject to judicial review, even if the substantive determination was not.
On that score, counsel, you agreed that the determination about the country conditions no longer meet the criteria is unreviewable.
Yes, the Secretary's substantive...
That final determination under, what is it, B, right? 4B, 3B, sorry. That's unreviewable.
The Secretary's substantive conclusion as to the existence or non-existence...
Well, it's a determination, right? I mean, that's what the statute says.
And that's how we define determination.
Yeah, and that takes effect once it's published in the Federal Register plus 60 days or something like that under 3B, right?
That's correct.
Okay. And that's the determination, and that's the effect of the statute. But you say that a court can enjoin it anyway.
No, they can, well, we didn't get an injunction here. We got 705 relief.
Postponement, yeah, I mean, I'm just looking at what the court said. I think in the Syria case said the defendant's termination of TPS status for Syrians is hereby postponed. And the DC Circuit in your case said the district court's postponed termination, right?
That's correct. That's section 705 of the APA.
How is that not judicial review of the Secretary's determination?
Well, I would say that, again, the claim...
I understand your process point that you want to look at some antecedent things, but how can it not be judicial review of the determination if you're postponing the determination?
Because well, I can't, it's difficult for me to answer that question without pointing out
It's difficult for me to answer the question too.
Well, no, but probably for different reasons, but.
Well, no, I don't know. I'm asking, I'm struggling with that.
No, I understand. The question comes down to, do you define determination as coextensive with a broader term like decision? And we see.
No, I'm working within your framework for purposes of this question. 3B says once the Attorney General, but we all agree that's the Secretary, makes a determination, the country conditions are no longer met, the determination decision takes effect, published in the Federal Register in plus 60 days, something like that. We all agree on that. And that's what the statute says about the effectiveness of the determination.
Right. The final agency action here that was postponed is, as counsel.
Is the determination.
It is the termination, not the determination, which is not subject to judicial review.
That's what you got.
That is consistent with McNary. It's consistent with Bowen.
Counsel, is your point that that judicial review runs to the claim? In other words, what is happening in the judicial review bar when it says there's no judicial review, it means the court cannot consider the claim that's being made, but that's different than what the court, having considered the claim, ultimately does.
Yeah, that's exactly right.
And so again, at the end of the day, if the court considers a claim about a defect in the procedure and thinks it likely, and therefore postpones the termination while that claim is under review, that's not the same thing as reviewing the ultimate determination.
That's exactly right. The determination here has the same meaning that it had in McNary and Bowen, which is the substantive the existence substantively of the conditions for designation, i.e., is Haiti still safe? The final agency action at issue here is the termination that was published in the Federal Register.
I appreciate all of Justice Jackson's points and yours, but the statute says that determination is effective basically automatically, right? And it tells us when it's effective, and it tells us how it's effective, and that's what the statute, that's what Congress told us. So once that determination's made, boom, it goes. And I'm just struggling with how that could be true, and yet it could also be true that judicial review postponing that termination decision is not judicial review of that determination.
Right, because the termination decision, the final agency action, includes substantially more than the determination. It includes things like when the effective...
Antecedent things, of course, that feed into that determination. I appreciate that. Okay, all right, thank you.
Would you like to address? Would you like to address the general's point, the Solicitor General's point that this would drive a truck through the judicial review bar?
I don't think it would, and no more so than, again, McNary or Bowen already did. And I would remind the court that in Bowen and in McNary, the plaintiffs in that case won, and maybe this is responsive to Justice Gorsuch's point, even though they were challenging the procedure by which their SAW determinations was made, they still obtained injunctions and invalidation of the underlying determinations that they were challenging. So this tension that we're identifying between the process and the outcome is one that this court has been, and that the law has been comfortable with for over 30 years now. As far as it driving a hole through the review bar, I would come back to the exact same point, well, to a similar point, which is the determination is off the table. We agree with that. Congress could not have intended, we say, for the for these antecedent considerations not to be considered, because when it had acted the TPS statute, it already had the benefit of Bowen, and after it passed the review bar, Congress, several years after it passed the review bar, Congress enacted IRERA, in which it retained the language from Bowen, from McNary. So it's reasonable to read the review bar in this case as consistent with that in Bowen and McNary. In other words, Congress knows how to write broader language encompassing more than a specific determination. It could write all questions of law or fact. And in fact, in some other sections of Title VIII, it even writes language that we think would preclude procedure and process claims. Like in another section of Title VIII, it refers to all procedures and policies. That's 1252A2A Romanet 4. So Congress knows how to write broader language if it wants to, but it chose not to do so here, even within the background of Bowen and McNary.
Justice Thomas, anything further?
How exactly does your equal protection argument work? The Equal Protection Clause applies to states.
Well, this is a claim that arises under the Fifth Amendment Equal Protection Guarantee.
Of life, liberty, and property.
That is the equal protection component of the Fifth Amendment Due Process Guarantee. That's
so how does it work?
Well, this court has held repeatedly.
No, how does your claim work? How do you get to the Fifth Amendment?
Because the Fifth Amendment constrains the federal government in the same way that the 14th Amendment constrains states.
Justice Alito, anything further? Justice Sotomayor?
The Fifth Amendment says the federal government can't discriminate on the basis of race, correct?
That's exactly right. And the other thing I would emphasize that I was trying to get at earlier is that even under this court's rationality cases, we still win. Remember the facts of Moreno. There was a facially plausible FDA program that did not allow unmarried households to receive food stamps. This court nonetheless said that there was something else at play there, animus against a particular group, a bare dislike of a particular group. And the president's statements, regardless of whether you consider them inherently racial or some other type of classification, reflect a bare dislike for Haitians in particular.
Justice Kagan, anything further? Justice Gorsuch? Kavanaugh? Justice Barrett? Justice Jackson? Thank you, counsel. Rebuttal, General?
Very briefly, Mr. Chief Justice, Congress balanced the risk that by enacting a judicial review bar, Congress balanced the risk that there might be some decision that's erroneous or baseless or off base evade judicial review against the risk of what we're living through here, which is judicial micromanagement of the sorts of foreign policy laden determinations and decisions that are naturally conferred upon the political branches. Justice Alito, turning to your convoy of trucks question, if you look at the briefing in this case, I think it vividly illustrates the concern that any exception that they put forth, and the exception morphs when they talk about it with different formulation. Any one of those exceptions, it creates an exception that would eviscerate the statutory or the judicial review bar here. So if you look, for example, at the Syria respondents, the claims they raise the consultation claim, but as I pointed out earlier, even those consultation claims are sort of to bake in substantive criteria. In other words, district courts are saying, well, you did consult, but your consultation wasn't thorough enough. Therefore, we give you a D+. We'll come back when you've got a B- consultation. Maybe we'll let you terminate at that time. And it gets even more striking when you get to their claims that things about the national interest criteria, which is unquestionably a substantive criterion. And then even further, if you look, for example, the Syria respondents, their pretext claim, they say, well, we're raising a pretext claim, and here's 4 reasons why we think this decision was pretextual. Reason 3 is a long discussion of how they think the secretary got the administrative record wrong and made the wrong kinds of judgments and so forth. And it gets even more striking when you read the Haiti respondents' brief, where in the 11 pages or so in which they discuss the merits of their claims, by the 2nd or 3rd page, they've kind of abandoned any pretense that what they're raising is procedural, and they're raising the whole panoply of substantive challenge, APA-type challenges to this particular decision. So to the extent there is or any exception to judicial review bar here, their own briefs, I think, demonstrate that it's going to collapse under its own weight. There's been reference to the presidential directives that were supposedly provided. There is a presidential directive that was provided. It was provided in the executive order, and the president directed the secretary to ensure that TPS designations are, quote, appropriately limited in scope and only as long as necessary to achieve the textual directives in the statute. And that is what the secretary did here. And then, Justice Gorsuch, as to your question, I do think it's helpful to end this case or end this argument by looking at their prayer for relief in their complaints, which says we are challenging the termination decision as to these two countries. We are saying that termination decision was unlawful. It should be declared unlawful. It should be set aside under the APA. It should be postponed under Section 705. And I think at that point, at a very high level, we are looking at a request for judicial review of the termination determination, and that is exactly what the statute bars. Thank you.
Thank you, counsel. The case is submitted.
Folks, if you're staying, please have a seat. Ladies and gentlemen, if you are staying, please remain in your seats. Thank you. Remain seated if you stay. Remain seated. Thank you.
We will hear argument this morning in Case 25-365, Trump versus Barbara. General Sauer.
Mr. Chief Justice, and may it please the Court. The Citizenship Clause was adopted just after the Civil War to grant citizenship to the newly freed slaves and their children, whose allegiance to the United States had been established by generations of domicile here. It did not grant citizenship to the children of temporary visitors or illegal aliens who have no such allegiance. This conclusion reflects the original